One thing that we do a lot at Jones Trial Attorneys is pursue diversion. Diversion is a way for our clients to achieve a dismissal of the charges without having to go through trial and pursue an acquittal. It requires more work on our client's part. Essentially, it's a program that we can establish to allow our client to earn the dismissal. That includes correcting the wrongs, paying back restitution, doing some self-help, and correcting all the problems that led to the criminal charges. And by doing so, the court is satisfied and willing to dismiss. So a few ways to get there. On misdemeanors, it's pretty easy. Penal Code 1001.95 establishes judicial misdemeanor diversion. That's where you can appeal straight to the court with a proposed game plan. Say this person qualifies, it's not a violent offense or doesn't involve children, some other restrictions like that, domestic violence. And here's what we think would be appropriate. Some help classes, maybe stay employed, do some community service, things like that. And the court can decide yes or no, this person qualifies for a diversion, and here's what the plan is. It can be between 6 months and 24 months. And at the conclusion, as long as the defendant has done everything promised, they get a dismissal. It also comes with an order sealing the arrest record, which is great. Really completely erases the offense as if it never happened, and is great for jobs, careers, immigration, things like that. With felonies, it's a little more complex. If a case is a wobbler, meaning it could have been filed as a misdemeanor or a felony, sometimes the judge will still consider misdemeanor diversion. They'll agree to 17B, the offense, which means reduce it from a felony to a misdemeanor, and then grant diversion on the misdemeanor PC 1001.95 terms. If it's not a wobbler, then we're looking at a few different options. If the defendant's in the military, active or former military, and there's a connection, a nexus between the military service and the offense that we can demonstrate, then they can be put on military diversion. It's a little bit more structured. It requires them working with a coordinator from the branch of the military that creates a tailored plan for that specific person. And similar to the 1.95 diversion that we discussed, as long as the defendant follows through on their course of action on the plan, they can achieve a dismissal and an order sealing the record. Another one that's still up and coming, but we use a lot, is mental health diversion. If a mental health diagnosis is connected to the offense, and we've got a game plan for how the person's going to receive, that our client is going to receive treatment and continue on a course of corrective therapy to address that, and they stay the course, the court can allow them to do that program and earn a dismissal at the conclusion of it. If the person doesn't fall into any of those boxes, but they're willing to put in the work, they're willing to do community service, pay back restitution, keep their life on track, and they don't fall into any of those buckets that we discussed, a lot of times we can negotiate with the prosecutors to say, hey, we can't do formal diversion, but would you consider informal diversion? Here's what we're going to have them do. If we can set the court dates out 6 months or so, and I can come back in 6 months and show that they have done A, B, and C, whatever it is, community service, restitution, anger management, self-help meetings, a lot of times the prosecutor will say, yeah, if we'll agree to kick the case out 6 months. If you can do all that, we'll either dismiss or significantly reduce the charges. A lot of times it's a reduction to a misdemeanor, which we can then expunge after a year. The last option for diversion, which used to be kind of the de facto arrangement, is called a deferred entry of judgment. That requires the defendant to plead guilty, to actually fill out a plea form saying, I am not going to trial, I admit that I did whatever the offense is, and here's the sentence I know I'm going to receive, unless, and then we build in the diversion plan. And this happens between the time of pleading guilty and being sentenced. So when you enter a guilty plea, it's not in your public record. It's in the court file, but you're not convicted, you're not on probation, you're not going to jail. And so the court then, as long as you satisfy the terms of the deferred entry of judgment, is to, at the time of sentencing, if you did all the work, you can get a dismissal or a reduction or whatever the plan is based on what you agree to do. And if you didn't do it, then you get sentenced on whatever's on the plea agreement. Might be jail, might be probation. We try to avoid that because we don't like our clients admitting guilt, entering a guilty plea, but it is a great final option to preserve the client's ability to maintain a clean record and avoid that criminal conviction. So we always go through these checklists, see what applies. Obviously, if our client's innocent, if they're maintaining their innocence, we're not going to say, hey, do diversion, but it is an option. It's a way that can essentially put the client's future in their hands. They know what they can do, and that if they do it, they will get a set result, which is great. It eliminates a lot of the uncertainty, stress, anxiety that comes with facing a criminal charge. So we love diversion plans. We especially like it when we have clients that come in, they say, hey, I screwed up, I did this, I want to make it right. Awesome. We've got plans for you. We're going to see which one of these applies, and we're going to fight for it to make sure that you are able to get the result that you deserve. You've owned up to it, you're willing to work for it, you want to make things right, do all that, and we're confident we're going to be able to get your case dismissed. So if you have any questions about diversion, these different avenues towards diversion, or if you have a case that you think might apply to one of these, or it's a game plan that appeals to you of earning the outcome that you want, ask me, drop me a line, ask me any questions. This is something that I'm really passionate about and that I've been advocating for since day one, becoming an attorney. So it's something I believe in. It's something that I have invested a ton of time, energy, and effort into, and I'd love to help guide you through it and answer any questions you might have. Thanks.